and the students for understanding about IPR. I take this opportunity to thank our management, Provici, Director of Bangalore campus for permitting us to provide this webinar specific mention and heartfelt gratitude to our beloved HOD, Sir Dr. Brahmananda sir, for being with us as a strong supporter in organizing this event. Today we have three resource persons, Mr. Santosh YB, Mr. Deepak P and Mr. Sahana DS. I would like to introduce here Santosh YB. He is having a 7 years of experience in patent field. He worked in India, US, European patent drafting and a patent prosecution. He has done graduation in IPR after completing his master's from MS Ramaya Institute of Technology. We are very happy, delighted to have you here, sir. Next resource person is Deepak P. He is ex-research associate of IP Origin Solution, Bangalore. He is having 6 years of experience in patent field. He registered as Indian patent agent. He completed his BTech in ECE from KVG College of Engineering, Sulya, that is in Karnataka, under VTU. We are happy to delight you have our resource person here, sir. Last but not the least, Mr. Sahana DS, working as assistant professor in CSE department, Bangalore campus. She is having a 2 years of teaching experience in the same field. We are happy to have you as a resource person here. Screen is yours, Sahana ma'am and Santosh sir.
Thank you, ma'am.
Thank you, ma'am.
Very good morning, everyone. Myself, Sahana DS, Assistant Professor, Department of CSE, Geetham School of Technology, Bangalore campus. Today, I got a very wonderful opportunity to speak about my experience regarding this intellectual property rights. So let's start with this. Before understanding or before going in deep about this intellectual property rights, I just want to tell you that what is actually this intellectual property is and why actually we're going to prefer going for patent and all. So very first thing I like to tell here is intellectual property is going to refer for a creation of a mind such as an invention, literary and artistic works, designs, symbols, names and images that have been used in the commerce. And this intellectual property rights play a major role in academics point of view. And if you are having a new idea, in order to go up with an innovative idea and in order to make that work as an economical one, so we go for this patent. So we shall see what are the things I will be covering in this intellectual property rights introduction part. Today I am here to explain you regarding a basic concepts, what actually the objective of the patent is, what is an introduction part of patent, what actually patent is, and what are the types of requirements, patentability requirements, what are the types of patents that we're going to categorize, non-patentable matters, what cannot be patented, who can file a patent, patentability search, because if I want to file a patent, we go into two steps. One is patent search and other one is patent drafting. And next is patent specifications with examples. So this is what we're going to study with respect to patent specification. So, coming to the contents, as I briefed out what are the things that we'll be covering here, this only tells about the brief introduction part about IPR. So, if I want to file for a patent and all, so we need to go up with having some brief idea in mind, what are the things I will be getting into my mind, and if I go for patenting and all. So this is the contents what I will be covering. And next thing is, we already know that if I go with the research part of, with research point of view, We know that already invention as well as innovation, these are the two pillars of our research. We already know this. So what is actually an invention is? Invention is something new or useful, or we're going to call it as a novel, a process or a method, and machine or an apparatus, article of a manufacturer, we're going to call it as an invention. What is actually an innovation? Improvement for already the existing one. So there is some sort of confusion regarding this invention as well as innovation. Invention is different when compared with innovation. So as I said earlier, invention is something new or a useful one. Innovation is we're going to do some sort of improvement for the already existing one. So significant contribution to an existing product can also be called as an innovation. Let me just give a simple example regarding this invention and innovation. We're going to say that, okay, Graham Bell have invented the phone. Okay, that is what we're going to call it as an invention. Invention in the sense, something improvement what I'm trying to do. So nowadays, that simple landline telephone have been replaced with many sorts of modifications, and we came across with a simple mobile phones. That we can consider it as an innovation. That is what we have done is, for an already existing one, we try to do some sort of improvement. Fine. And coming to the next thing, what is an objective regarding this patent? So what is actually we're going to learn regarding this patent? Very first thing is, if I file a patent, we're going to get the protection for the, in order to provide the protection for the creativity of the creators. Second thing is, in order to promote the creativity of a new creator. And then, so what is actually to promote the creativity of a new creator? It's a kind of chance in order to give for a creators in order to promote or establish their own ideas. And the third thing is, in order to accelerate the technological and industrial development of the countries. So in order to accelerate in the sense, in order to boost up the country's economical growth. So in order to accelerate the technological as well as the industrial development of the countries. So this is the third objective. In order to provide the exclusive right to the invention and afford protection against unauthorized use of the invention by the third parties. So this is regarding the objectives of patent. Next thing is, you will be getting a question. What is actually this patent? Why actually we need to provide this patent? And you have seen this, whatever I'm displaying on the screen, what is actually a patent is. Let me just give a simple example for this. Imagine you have invented a new toy for your kid, a small kid who is playing. You have developed a kind of toy. So when you have developed it for the first time, you were not sure that whether all the people will like that or not. Your intention was that whether I'm able to give that thing for my kid or not. Say after a year of using it, some maybe liked that particular toy, whatever you have developed, and they start loving it. And even they started using with that. At that time, you might feel like someone will copy your idea. And what you may feel is, you're going to think that you're going to lose your identity. So, this is a place where we're going to get an idea of patent. This is a place where we're going to have an advantage of patent. I need to safeguard the individual right to my invention. This is what actually the patent going to give. So what you can do, you can establish the ownership for your invention by registering for the patent under the Indian laws. So now you will be getting the complete patentable rights for your invention of a toy, whichever you have been developed. So this is just a simple example to make you understand what is this actually patent is and where actually the patent comes into the picture. We shall go in brief regarding each of the topic regarding the patent. So what is actually a patent? What is actually the patent stands for? We shall see now. A simple definition to make you understand what is actually a patent. Patent is an exclusive right which has been given by a country to the owner of an invention in order to in order to use, in order to manufacture, and also in order to market the invention. So, a patent is an exclusive right given by a country to the owner if it is an invention or it might be the innovation. So here I have said like it, which is nothing but an exclusive right. So what is this exclusive can utilize the invention without the consent of the patent holder. Keep in mind regarding whatever I have given an example, regarding toy which has been developed for a kid. So what I am trying to do here is I am trying to give the give some other person in order to make use of that toy. So I'm thinking in an economical point of view. And next, many will be having a question saying that, okay, who will be giving the permission for this patent? So this will be completely granted by the government for your novel invention, or we can also call it as a new invention for a limited period of the time. And this, what is the period duration and all, sir will be discussing in the next upcoming slides. So, and next is, you might also be having the confusion. So, how I can get the patent and what aspect I can get the patent? I can get a patent on a new product which has been developed, a modification for an already existing one, as I said, which is nothing but an innovation, which can be patent for designing, which mainly deals with some mechanical aspects and useful way to do the things. Coming to the next thing, so we need to have some sort of requirement regarding the patent filing. So what are those patentability requirements? We need to keep in mind regarding three important things. The very first thing is, whatever the patent we're going to file, it should be a new one. Second requirement is, whatever the patent we're going to try to patent for it, it should be following with the inventive steps. And the third one is, it should have the industrial application. So let me tell you in brief regarding whatever I have told the requirements regarding. The very first one is, the invention must be a new or a novel one. That means invention must never be made public in any way. So before you file the patent, whatever the idea or a prototype or a model, whatever you are having, it should not be made public before. Anywhere before the date on which the application for a patent is filed. So this is regarding the very first requirement to keep in mind before filing for a patent. Second thing is, an invention, it must involve with the inventive steps or invention steps. So what is this invention steps? Invention steps means starting from the design point of view until you're going to give that particular product or a process until you're going to give it for a market. So whatever the steps will be involved in between, everything we're going to call it as an invention steps. That's what we will be calling it as a invention must be a non-obvious to the person who will be skilled in that particular art. So here I'm having a word called non-obvious. So what does actually the non-obvious means? Non-obvious in the sense, I will just give a simple example for the word called non-obvious. So go back to 15-20 years back, wherein we were not knowing anything regarding artificial intelligence. I'm just taking an example of our CSE. If we just go back 15 to 20 years back, we were not knowing anything regarding the machine learning, artificial intelligence like that. But at that time, our work, it was treated as a non-obvious one. But now, come back, and presently what we are having is, we are completely dealing with the artificial intelligence, machine learning, cybersecurity aspects and all. That means, at that time, the people, before 15-20 years back, the people can go and they can file for a patent because it was not the usual one, which was treated as a non-obvious one. Now, presently, the artificial intelligence and machine learning have been used by majority of the people. So now I can treat that particular thing as a non-obvious one. And next thing is, it must not follow plainly or logically from what is already known. This is regarding the second requirement of patent, which is nothing but the inventive steps or invention steps. And the third one, very important, the patentability requirement. With regards to this patentability requirement, the invention, it must be having the industrial application. For the patentable, the invention has to be capable of handling the industrial application. So it should have some sort of industrial application for whatever we're going to file it for a patent. It can be used by any of the industry because we need to get some sort of economy. So for that sake, that can be used by any of the industry, and that invention has to be capable of handling the industrial application. And also it may include any useful practical activity from purely intellectual, or we can also treat it as the aesthetic activity. And this is regarding the patentability requirements. Coming to different types of patent. So there are three categories of the patent we generally going to make use depending upon whatever the prototype or a model or whatever the process you're going to give. upon that, we're going to categorize the types of patent into 3 categories. That is utility patent, plant patent, and also design patent. So what is this utility patent is? Most common type what we will be getting granted. That is whatever we usually CSE, electronics, or something like branches, different branches of engineering, what we usually go for patenting. It might be a process, it might be a machine, it might be a manufacturer or article of a manufacturer, it might be any sorts of composition of the matter. That we're going to call it as an utility patent. Coming to the second one, which is nothing but the plant patent. So this will be, let me just give a simple example for this plant patent. Say for example, someone has developed a hybrid rose, wherein the middle portion of that particular rose will be enclosed with a red colored petals. Surrounding the red colored petals, in the middle row, we might be having the blue colored petals. And outside the boundary of that red, blue, and then we're going to give it as a green. That is what we're going to call it as we're going to state it as a hybrid plant or hybrid rose. So for those kind of innovative or inventive new one, we can go with a plant patent. Coming to the third one, which comes as a design patent. Let me give another example for this. Say, for example, Joy Lucas has designed some sort of ornament. I just want to take an example for ornaments. So, Joy Lucas have developed some new kind of ornament. So, at that time, what might happen is, they have gone for patent. That design should not be used by any other jewelry shops or jewelry industries. So if they have been given patent for that particular ornament, it has already been patented. I cannot go with any other jewelry shops need not go for going to design the same kind of pattern. So this is regarding the example of design patent. So our next thing comes into the picture of, many will be having a confusion. So I'm having an idea now. Okay. So now what are the things I need to keep in mind whether my idea is patentable or not patentable? What are the things that I need to keep in mind to know whether my idea or a prototype, whatever I have been designed, can go it with a patentable or not patentable? So let me just mention some of the main aspects which cannot be taken for patentable. What is the first thing is an invention which could be a contrary to the public order or morality, or which causes the serious prejudice to the human, animal, or a plant life, or health, or to the environment. A very good example is new type of gaming machine or new type of gaming application. So we can take a general example of PUBG itself. So second thing, inventions which are related to the atomic energy, because the central government has the sole responsibility for the development of atomic energy. Let me elaborate this thing. So what is actually the atomic energy? Say for example, they have designed some atomic bomb. If they want to experiment that, so the government of each of the industry will not be allowing you people in order to experiment that particular atomic bomb explosions in your places where the people will live. So in turn, what they will do, they go and experiment under the seashores like that, right? So that example you can consider. So only that atomic energy related inventions cannot be patented. Discovery of any living thing or the non-living substances or the objects which are occurring in nature. This can also be not treated as a not patentable matter. Coming to the next kind of thing which cannot be gone for patentable, mere arrangement or rearrangement or duplication of the known devices. Let me give an example for this. Say for example, you have designed some sort of a method. In that, you might be using some sort of Raspberry Pi. And what modification is, you have designed the same kind of context, but what you have done is, you have, instead of going for 8080s like microprocessor changes and all, instead of going with the microprocessor, you might be placing some sort of other rearrangement. So the device, whatever you will be using, will be the same, but the idea or a context is same, right? So in that particular thing also, we cannot go for patentable thing. Next thing, an invention which is going to affect the traditional knowledge. So traditional knowledge in the sense, I will be just giving a general example for this. In the year 1985, turmeric was already present in our country. But what the US people has done now, US people has went and filed for a patent for turmeric. And we are the originators of we Indians are the originators of this turmeric. But we had not done any sorts of patenting. So what the US people has done is, they got to know regarding the turmeric, and then this went and tried to file a patent for that. So at that particular period of the time, the Indian people got to know regarding this, and they gone and opposed for that particular patent. So at that time, that particular patent that has been filed by the American country, it has been opposed and it has been refused. So an invention which is an effect in the traditional knowledge cannot be patented. Next thing, a mathematical or a business method or a computer program cannot be patented. So let me brief out the thing over here. A mathematical method, say for example, in our numerical methods and all, we'll be using many different sort of methods. Say for example, Newton-Raphson method, something like that, right? So De Morgan's law, those things and all cannot be patentable. Mathematical method cannot be patentable. And business method, it can also be not patented. And also, our software program alone cannot be patented. And coming to the next one, a method of agriculture or a horticulture cannot be patented. What is the reason for not giving the patent for this kind of method is, a farmer might be a poor one. And if anyone have invented a new kind of method of agriculture, so what other people need to do, say for example, a farmer need to do, he need to get the permission. That is, already it has been patented. That method has been already been patented. So what a person need to do is, now he need to go and approach the one who has already been patented for that particular agricultural method. He need to take the permission for him. He might also pay some sort of money for him in order to utilize the method that has been patented. In order to make use of that, the farmer need to spend lot of money. So for those kind of things also, he might be poor, that farmer might be poor. So only it cannot be patented. So Indian laws or Indian Patent Office has been avoided in order to give the patentable aspect for agriculture or the horticulture method. Next thing is regarding any process for the medicinal, surgical, curative, diagnostic, therapeutic or other treatment of human beings and animals, it can also be not patentable. That means, see, I'm just telling you one important thing over here. A process cannot be patented, but a device, whatever that have been devised or it has been invented, that can be patented. The procedure or the process, whatever they're going to use, they cannot be patented for the medicinal aspects. And the plants and animals in the whole or part thereof, other than microorganisms, they can also be not patentable, because they can conduct some sort of experiment and they can develop some sort of animals, right? Or some sort of plants. That also cannot be patented. Seeds and biological processes for the production of plants as well as animals can also be not patented. And last one, a literary, dramatic, musical or the artistic work, including cinematographic work and television products, can also be not patentable. This last point, what we're going to call it as, a copyrights, which we'll be discussing. Some will be having confusion regarding copyright, trademark as well as patent. Let me just try to give the differences. So hope you people have understood what are the things that we cannot go for patentable. I just want to tell one thing for my students as well. Software alone cannot be patented. Software programs or software applications cannot be patented. Next thing. Now, you might be also getting some sort of confusion. So, which person? Only a researcher can file a patent? Or who can able to file a patent? Can I file the patent? So, let me give an answer for those things. Either alone or jointly you can file for a patent. That is, by any person who claiming to be a true inventor or a first inventor can be taken as can go up with a filing for a patent. Second thing, by any person being the assignee of a person claiming to be true and the first inventor can also be for applying for a patent. And the third one, by the legal representative of any, by the legal representative of any deceased person who can immediately before his death, so that he can hand over that particular application to the other person who might be very close to him, or he might be a family person. He alone also can go and file a patent. And one more thing I like to clarify over here. The thing is, if we are doing any sorts of research papers and all, what we used to do is, we're going to differentiate as a first author, second author, third author, like that. But if you come for regarding this particular patent aspect, there is nothing like first inventor, second inventor, like that. Whoever may be the person who will be involved over here can be treated as a inventor, or true or a first inventor only. Next thing, patentability search. In the same manner, what we going to do with the literature part of our research work, here also, before filing the patent, we go for two aspects. We need to keep in mind two aspects. What the research or patent analyst will do is, he going to do two important steps. One is patentability search, and the second one, he go for patentability draft. So what is actually the patent searchability? What they're going to do in patentability searches, in the same manner, what we're going to follow with the literature work. That is, effective searching of the patent document and other source of technological information, which going to requires a solid knowledge of the technical field, which has already been predefined. Say for example, which is already an existing work, if it is there, and if it is there, what inventive steps I can follow, and I can make the changes, I can go with the patent filing. So this things and all will be getting to know if we go up with this patentability search. Coming to the next one, following search criteria are used for searching the information by using. In the same manner, what we're going to search for our research work, we are also going to search based upon certain criteria, whether that particular patent is already present or not. So on what are the search criteria are? It might be the keywords, it might be the patent classification, dates, name of the applicant, and also patent reference or the identification number. Keywords in the sense, say for example, an inventor has given a complete abstract for a patent analyst. What the patent analyst will do, based upon the keywords that are present in his abstract, he is going to start searching whether that particular work is already present or not. Say for example, I'm just finding out the walking stick for a blind man. So I'm going to get the words as what are the devices, walking stick for a blind people. In the same manner, that is, we're going to check with some sort of keywords. Patent classification, whether it is dependent on the CSE project or CSE prototype, or whether it is a mechanical oriented classification. In the same manner, we're going to categorize. Coming to the third one, which is nothing but dates. We also going to just check it out with, very importantly, we're going to check with this dates. Why? Because we'll be getting the priority date, application date, when actually the application have been filed, publication date, and when actually the patent have been granted. And fourth one is the name of the applicant, whether it might be a very larger organization, and whether it might be the smaller organization, and whether it is a huge organization which might be tagged up with many of the companies with different countries. It's going to search based upon the name of the applicant as well. Coming to the last one, patent reference or identification number. That is what we're going to search is, we're going to search based on the application number, publication number, as well as a patent number. Next thing is regarding the specification aspect. So what is the specification? Why we need to have the idea about the specification is, specification will give you an accurate description of the patent, stating how the invention can be carried out by the method which is best known for an applicant. So only we're going to call it as a detailed description can be known by a specification, whatever we're going to specify. And next thing is, it's going to, the final thing, after getting to know what is the best method to carry out our work, it's going to, this particular specification will end up with a claim, or what actually the claim will going to illustrate is, it's going to tell about the scope of the invention, or in other words, I can also say that an objective of the invention or the purpose of the invention for which the protection can be claimed. This is regarding the specification aspect. And also, we're going to differentiate the specification based upon the applicant into two categories. One is I can call it as a provisional specification, and second one is I can call it as a complete specification. So what is this provisional specification? So provisional specification is nothing but it's going to give the abstract idea. That means which going to describe the nature of an invention and which contain the description of essential features of the invention. So in other words, I can say that which going to give, which whenever you don't have an idea about what prototype or a model you need to use, or else whenever you're not familiar which prototype or which model cannot be used for my method. You will be having just an abstract idea. So or else I can say it as a context. So if you just have an idea of your project, or if you have an idea of your application, whatever you want to design, so at that time you can go with the provisional specification. I can say that in order to get the priority date, we can go with this provisional specification. Next thing is, I need not include the claims and details of the manner in which it need to be performed. As I said earlier itself, claim is nothing but claim. Based upon this claim only we will be getting the grants for our patent. This is one of the important thing. So why actually we are focusing mainly on the claims is which going to give the complete specification of your idea or your work, whatever it has been, or inventive or the invention or innovative idea. It will be dependent on this particular claim only. So only I have told provisional specification which going to give only the abstract idea or a description. If you don't have any idea regarding the prototype or a model, what kind of algorithm you need to use, what kind of device you need to use, if you don't have those kind of information in your mind, but you are only having the idea of designing something new or performing some sort of innovation, at that time you can go for provisional specification. Only advantage is that, so from the date of filing you will be getting around 12 months in order to give the complete specification. So after giving your abstract idea, so you'll be getting some more 12 months additional time in order to give your complete specification of telling what is a prototype, what is a model, what is a method, what is the algorithm, what is the device you will be using. In order to know all this information, you can go with this provisional specification. Let me tell you what are the advantages regarding this provisional specification. The thing is priority for invention. So anyhow, you and your friend have been discussed regarding your new idea, and here you already have in mind regarding complete specification as well, but you didn't approach the patent office and you didn't file for a patent. But what your friend will do, he just got to know your idea, and what he immediately do, he going to go with the provisional specification and go on to file for the patent. So who is the main advantageous person over there is the person who has filed the patent for the very first time. That is, advantage is the priority for invention. No risk of losing the priority. So I already filed a patent, so I need not worry of, because my priority is the first one when compared with my friend. So it is not having any sorts of risk for losing the priority. Liberty to develop. You will be getting a chance in order to go ahead and start developing your own prototype or a model. Disclose to interested person to obtain the financial support. So what, you have already filed a patent, so you can take a help from different larger organization in order to carry out your work, and then you can go for a patent granting. So you can tie up with the companies. That is what financial support. Virtually extended term. So you will be getting the 12-month duration extra in order to change your mindset of using. Say for example, sometimes you felt while giving the provisional specification, you felt like, okay, I can use Arduino. You just felt, but you didn't specify that in provisional specification. So what you can do, you got to know that, okay, instead of using Arduino, my work or my prototype is going to work well if I use the Raspberry Pi. So you're going to get the chance of extending the term by making use of this provisional specification, and utilize for exploring the commercial feasibility. So last one is avoid incurring the further expenses if no commercial possibility. These are some of the advantages what we are going to get when we go with the provisional specification. Next is, I told like specification is of two categories. Second, provisional specification, and second one is a complete specification. So now assume that you have already given with the provisional specification, and now you're going to get the complete specification. So how we are going to give the complete specification is, what is it actually complete specification is? complete description or full description about our invention will be given with this complete specification, including simple matter starting from scratch. What are the things that are needed? What is the method you will be using? What is the algorithm you will be using? What is the device you will be using? And what kind of hardware equipments that are needed? Everything will need to be illustrated in this complete specification. And next thing, what are the things it's going to cover? It will cover the title of your invention, the field of invention, whether it might be your computer science, electronics, mechanical, those kind of things. What is the background of invention? That is prior art. In our research work, we're going to call it as a literature survey, similar kind. Advantages and our uses of that particular invention. And then object of invention, statement of the invention, detailed description with the drawings or examples, if anything is there, and claims. Claims plays a very important role in order to file for a patent. So everything, we will be just taking an example to illustrate this, how actually the claims will look like. And we'll also be having the abstract. So this is what the specification regarding. Next will be carried out by Deepak sir. So he will be taking a simple example regarding this, how actually the claim will look like, and he going to explain. Thank you. Deepak sir.
Thanks, Anam. Am I audible?
Yes, sir. Yes, sir.
Yeah. So this is a very simple example of a claim of iron box, which will shut off automatically when there is no use of the iron box. So this is basically a very exemplary invention, not a real-time invention. This is, I'll just exemplify how you can write the claims for this. So the advantage of the invention is to, not to harm the clothes or the garments whenever the iron box is switched on and not in use. Okay. So Sana, please move on to the next slide.
Sure, sir.
Basically here, before going to the claim, let me just, summarize what are the important elements of the iron box. So here there is a temperature control, which will, heating element, which will actually control the heating of the iron box, and a handle portion. And there will be a touch sensor, which will detect the touch of the person or the user, whoever using it. If there is no touch detected for a predetermined time, for example, let's say for 5 minutes, and then automatically it will be switched off. Otherwise, there is another alternative embodiment, we can say alternative form. If I do not want to use a touch sensor, if I use an accelerometer, which will detect the movement of the iron box. So if there is no movement for a predetermined time, then definitely it will shut on after there is no movement. So Sahana, just go to the next slide of the claims. Yeah, so this is just how does the drawings look like. So we have to present always the line drawings in the patent office rather than giving black and white drawings. So this is an example, the first example which I already explained, the touch sensor. So touch sensor is configured to sense the touch of user. So I think alternative embodiment is accelerometer. Go back to the previous slide, Sahana. I just want to explain the claim once. So here I can say in the claims there are three parts. One is a preamble, one is a body, and one is a connecting phrase of the preamble and body. So here a clothes iron, that is a preamble. Usually we do not limit any preamble while writing the claims, and comprises of, I would say to better writing, comprises of, sometimes we write comprising, just because it's an open-ended statement. So here we have to put all the elements of the invention. So I understand the new thing in the invention is to to switch off iron box after predetermined interval. But then we have to put all the elements of the invention just to make Sahana or anybody.
Sir, it's online, sir. It's okay. We should carry out first. Thanks.
Am I audible? Hello?
Yes, Deepak. Yeah, the next following slides will be continued by me.
Yeah.
Hello.
Thank you, Santosh. Yes, thank you.
Yeah. Very good morning to one and all who are present here. Now I am going to request for examination. The government examiner will examine the application, the filed application. Okay. After the filing, after the examining, the examiner will send us the first examination report. After getting the first examination report to the patent agent, then the patent agent or patent analyst will sit with the inventor, who exactly the filed the invention, will sit with, they both will discuss the examination, what the examiner has asked us to change us, and he'll be asking some queries to sort out. At that time we'll sit together and finalize, and we'll send a response to the examiner. Once if you send the response to the examiner, he'll see whether if it is satisfied, he'll grant a patent. If it is not satisfied, he'll be sending us again the second examination report. If the second examination report is not satisfied, it will be rejected. If it is satisfied, then it will be granted. And during this process, we might also get opposition from the third parties. You should be capable of justifying your invention or innovation with respect to the third party queries. You should be capable. And there is there is some acceleration examination, because in order to get a patent grant, it takes around 2 to 4 years, because depending on the examiners, you know that how exactly like our government officers, it takes around 2 to 4 years. Now there is an acceleration of the process, because if you file an acceleration of examination, generally the application will be granted within 2 to 3 months, but there will be extra fees all with respect to this one. And this is a very good process that now our government has been started. Like many, like in order to get acceleration examination, there are two criteria, because if you get an acceleration examination, you should have some startup. The startups is the acceleration examination is given only to the startup companies, and for inventors also, like normal inventors also will be given, but the inventor should have some female inventor in that one. If you have one female inventor, at that time you will get an acceleration of examination chances. Otherwise, like you should follow the normal steps what I had explained. Thank you.
Thank you, Santosh sir. So, and some will be having some confusion regarding this copyright, trademark, as well as patent. This all comes under the category of intellectual property rights. So let me just tell the differences between this copyright, trademark, as well as patent. There is some sort of confusions regarding this copyright and trademark as well as patent. So what is this actually a copyright is? A copyright is nothing but a legal term which is used to describe the rights that a creators have over their literary and artistic works. So for example, we can take an example of the book publishers, the music, paintings, sculpture and films, to the computer programs, databases, advertisements, maps, as well as the technical drawings. So I hope this difference between the copyright as well as the patent have been clear. That is nothing but a kind of legal term that will be taken up by the company people in order to get the rights, what we're going to call it as a copyright. Second thing is regarding the trademark. What is this trademark? You might be noticing many of the MNC companies, they will be having their own sorts of logos. Say for example, Microsoft, Infosys, Apple, Cola and news channels, chocolates and those kinds of things. So these are nothing but we're going to call them as trademark. A trademark is a sign capable of distinguishing the goods or the services of one enterprise from those of the other enterprises. So this is regarding the trademark. And next thing, so this is all we meant to explain you something related to brief introduction about the intellectual property rights. So something related to a patent, what we need to know in brief. Something before filing for a patent, we need to know something regarding the patent rights. So this is some basic things which need to be known, starting with what do you mean by a patent, what do you mean by what are the patentable requirements are there, and then starting with which aspects which cannot be gone for patentable matters, right? And then we need to know about the specification, provisional and the detailed complete specification, what is actually a claim and what is the difference between copyright as well as a trademark and patent. So these are some basic things, and up to our knowledge we have given some sort of explanation for you. Hope this will be helpful for you. And if you have any queries regarding this patent, and if you want to file for any patents, if you want to go with the patent analyst, then Mr. Santosh sir is there, and also Mr. Deepak sir is there, who can help you out in order to file for a patents. And now, in academics point of view, and even in the point of some of my students are also working on some. They also became some entrepreneurs. If they want to design for any sorts of logos and all, or trademark, what we're going to call it as, they can also go with the patent aspects. So this is the contact details of the person who is a guest lecturer, and he's Mr. Santosh sir. If you want, you can take the details, and if you have any queries, you can approach him. And, that's what we meant to say. Thank you. And if you have any queries, you can go ahead. Swastika ma'am.
Sanju sir.
Yeah. Good morning, all. Good morning, dear resource persons of this session, Mr. Deepak sir, as well as Mr. Santosh sir and Mrs. Sahana ma'am.
Thank you, sir. Thank you.
Yeah. We hope you enjoyed the participants. I thank the participants. I hope you all enjoyed this session with the great informative idea. I mean, great informatives and knowledgeable on the how the patent can be patented, what is meant by a patent, and then what are the different types of a patent, what kind of patent that we can able to claim as a patent. This and all the informatives that has been given by the resource persons. The session was so informative, sir, and then so informative, madam. And we could be able to get the basic knowledge about the IPR, that is intellectual property rights, and checking about the novelty of our ideas and about the ways to file it. That is what we got it from this session. We all hope that as a researchers, as a student, that we can sure that we will be able to do something on this IPR towards the building a nation's economy. We all will do that. Thank you, Santosh sir. Thank you, Deepak sir, and thank you, Sahana ma'am.
Welcome, sir. Thank you.
We look forward to have an association with you in the future too, and that the management and the administration and our beloved HOD sir for arranging such an event. Once again, I am thanking everyone, dear participants, and then the resource person, everybody.
Excuse me, sir.
Yeah.
I just want to say something, convey something regards to the Geetham University.
Yeah, sure.
Lastly, I thank to Geetham University and Dr. Brahmanand sir and Dr. Dayanand sir and Dr. Jina ma'am for giving us this wonderful opportunity to share our little knowledge and experience about the intellectual property rights. Thank you, Ananda.
Yeah. Once again, I am thanking you, everybody, even the resource person, administration, and then Geetham University's administration, and our head of the department and faculty coordinators, as well as the faculty members and everybody. And I would want to tell you something regarding the participants. Dear participants, the participants links is shared in the description. You just give these details and fill that description form, and then you will be able to get the certificates on this. Thank you. Once again, I thank you all. Thank you, sir. Thank you, moms. Thank you.
Thank you, sir.
So,
It's there, ma'am. It's not there. Please check it once again, ma'am. YouTube link only I have pasted. I have checked it. It's there in front of me only. Yeah. Where, ma'am? I couldn't able to see, ma'am. Maybe I have logged out from that, ma'am. If I am there, the participation form which I have shared, you can see. Ma'am, even the thing which I am sharing, I can see. Now can you see in the... Ma'am, can you able to see now the... After that I have sent. I will send once again. Check, ma'am, if it is not there.
ನೀವು ಕರೆ ಮಾಡುತ್ತಿರುವ ವ್ಯಕ್ತಿಯು ಮತ್ತೊಂದು ಕರೆಯಲ್ಲಿ ಕಾರ್ಯನಿರತರಾಗಿದ್ದಾರೆ. ದಯವಿಟ್ಟು ಕಾದಿರಿ ಅಥವಾ ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ಪ್ರಯತ್ನಿಸಿ.
ಹಲೋ, ಪಾರ್ಟಿಸಿಪೇಷನ್ ಫಾರ್ಮ್ ಲಿಂಕ್ ಇಲ್ವಾ?
ಲಿಂಕ್ ಇಲ್ಲ ಅಂತ ನೋಡಿ. ಅದರಲ್ಲಿ
ಯಾರು ಫೋನ್ ಮಾಡಿದ್ರು?
ರಾಜೇಶ್ ಇವರು ಕಾಲ್ ಮಾಡಿದ್ರು ನೋಡಿ.
ಅಯ್ಯೋ, ನಾ ಒಂದ್ಸತಿ ಹೋಯ್ತು ಅಂದ್ಬಿಟ್ಟು 5 ಸತಿ ಪೇಸ್ಟ್ ಮಾಡಿದೀನಿ ನೋಡಿ. ಒಂದು ನಿಮಿಷ. ಹಲೋ
ರಾಜೇಶ್
ಸರ್.
ಇದು ಲಿಂಕ್ ಇಲ್ಲ
ಸರ್. ಲಿಂಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಒಂದು 5-6 ಸತಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಇದು ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ನೋಡಿ ಒಂದ್ಸತಿ. ನಂಗೆ ಯಾಕೋ ಡೌಟ್ ಆಗ್ತಾ ಇದೆ.
ಒಂದ್ಸಲ ನೋಡ್ತೀನಿ, ಒಂದೇ ನಿಮಿಷ.
ಸರ್.
ರಾಜೇಶ್.
ಸರ್.
ರಾಜೇಶ್.
ಸರ್.
ಕೆಳಗಡೆ ಲೈವ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ ಚಾಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರಲ್ವಾ? ಅಲ್ಲಿಲ್ಲ ರಾಜೇಶ್, ಲೈವ್ ಚಾಟ್ ಅಲ್ಲಿ
ಇಲ್ವಾ? ಸರ್, ನಾನು ನಿಮಗೆ ಕಳಿಸ್ತೇನೆ, ನೀವು ಹಾಕಿ. ನಾನು 6-7 ಸತಿ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ.
ಪ್ಲೀಸ್ ಫೈಂಡ್ ದ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಫಾರ್ಮ್ ಅಂತ ಇದೆ ಅಷ್ಟೇ.
ಹೌದಾ? ನಾನು ಪೇಸ್ಟ್ ಮಾಡಿದೆ ಸರ್. ಇನ್ನೊಂದ್ಸತಿ ಪೇಸ್ಟ್ ಮಾಡ್ತೀನಿ, ನಿಮಗೆ ಕಳಿಸ್ತೀನಿ, ನೀವು ಮಾಡ್ತೀರಾ? ಕಳಿಸಿದ್ದೀನಿ ನೋಡಿ. ವಾಟ್ಸಪ್ಪಲ್ಲಿ ಕಳಿಸಿದ್ದೀನಿ ನೋಡಿ. ಅಲ್ಲೆಲ್ಲೋ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದ್ದೇನಪ್ಪ.
Hello, Satika ma'am.
Yeah, sir.
Yeah, can we end, ma'am?
Yeah, sir, we can end. But once they have to fill the form, right? Let them